All right, David Parsons here, lawyers in the attic at the law offices of Bamieh and DeSmith in Ventura, California, as usual. Ron Bamieh is in the midst of a big trial that's going on over the last couple weeks. Jacob Caliboso, we've been updating you on the proceedings. I went to court yesterday, witnessed a couple things. How's it going, Ron? How's the trial going? How far are we along?
Uh, Today we have a half day from 1:30 to 4:30, um, and the people's case should be to the jury by Wednesday, and then we'll start our case Thursday morning. So we're moving along at a good pace. We'll probably argue it either Friday or Monday of next week.
Okay, so what I witnessed yesterday, almost entirely, when I went to court, was an officer testifying in detail about the car accident, offering lots of photographs and measurements. The material went on for a couple hours, and my thought was, and I wanted your response to it. My thought was, do prosecutors risk boring a jury with long, detailed sort of um, exegesis of a car accident like this with all these details?
Well, that officer had been on since Thursday of last week, all day Friday, and then all morning, and then you saw my cross when you got there.
Hmm.
So the prosecutor, even though we're conceding many of the issues in this case, continues to put in ad nauseum evidence that is not contested that she could put in.
That's what I was wondering about because it feels like your case is not really, yeah, contesting any of that information. The accident happened.
Well, no, not the accident happened. I mean, you could put that all in. Like she used 39 pictures yesterday. She could have done it with 5 or 6 pictures. She didn't need all those pictures.
How typical is that during a car accident case?
Well, it depends on what's being contested. Like my theory as a prosecutor is to make the case as simple for the jury as possible. And so I would never put in a ton of evidence on uncontested facts. I would just say those they're conceding all this. They're conceding all this. And I'd prove it because you have to prove it, but you don't have to do it what she's doing it. Part of that is she's very young and that she hasn't had a lot of experience with murder cases. And she could be paranoid that she has to do something.
Mm.
And she may not believe that we're not contesting anything, even though I've made it clear at every situation that I'm only cross-examining on very certain specific areas. I don't care about a lot of the case. Not I don't care, but I'm not contesting a lot of the areas. Yet she continues, like she has this theory that is ludicrous, that she has to say he was impaired due to marijuana, when the level of marijuana in his system was so minuscule to the amount of Xanax that there's no way the marijuana had any effect on the driving in comparison to the Xanax. And she keeps trying to make it so it's a marijuana Xanax case where it's just a Xanax case, and she's making it more complicated. I finally had an expert on there yesterday, their expert, and I said, considering the level of Xanax in this person's system and the level of marijuana, would marijuana have a contributing factor to any of his intoxication, or would it mostly be due to the Xanax? And he goes, at these levels, it's just the Xanax. He just
Mm-hmm.
corroborated what anybody with any common sense would say. But she has spent probably an hour and a half of jury time on developing expertise to marijuana, what marijuana symptoms of intoxication are,
Mm.
how marijuana can impair driving, and all this crap when the case is about Xanax. And to me, it just shows a lot of inexperience, and also, in my opinion, could affect how the jury sees the case in terms of why is she doing all this.
Mm. Yeah, I felt the same way watching the prosecutor yesterday. I felt like the information was repetitive, and it kept coming back to the car accident stuff, but and all the details of like the road, and the skid marks on the road. But one detail that I thought was interesting, I wondered your reaction to it when you were doing your cross of that officer who was at the scene of the accident. You sort of made a point about sort of how far exactly did Jacob's car cross over the double yellow line,
Mm-hmm.
and the measurement of that, which seems like it's 6 feet, and there's a curve in the road there. Is part of your theory of the case that this is sort of a typical accident that might happen at such a curve in a dark area? In other words, are you going to try to mitigate the intoxication element of it and just say this is an accident that happened?
No to the mitigation intoxication element. Our theory of the case is very simple. He was addicted to Xanax. He had incredibly high tolerance. His experience on Xanax made him believe that he could drive safely on Xanax. He had no prior incidents at all. Hundreds of times he was high on Xanax driving, no crash. That night he drove to Panda Express, a gas station. He drove his friends home. He drove all over Camarillo and Oxnard that day high on Xanax, no problems. This accident, even though it's his fault, he drifted over. That's his fault. He probably drifted over. He did drift over because he was impaired by Xanax. However, when you look at it, he drifted over on a curve, right? And the evidence that you didn't see was the evidence is that he was turning right, but he didn't turn right far enough. Like he was doing what he was supposed to do, but he wasn't doing it as hard enough. That's probably due to the Xanax.
Do we know how fast he was going?
55 miles an hour, which was the speed limit. So he's driving fairly normally, except for drifting. Okay, and the point being is that it's not like he was driving in the other lane, shit-faced, and didn't know where he was at.
Right.
He drifted over, which he shouldn't have done. He probably wouldn't have done if he wasn't on Xanax. But it wasn't as it's not one of these things where he's driving on the wrong side of the road for a half hour right at oncoming traffic that he's that out of control. He's not that out of control. Matter of fact, he had driven basically for 20, 25 minutes without incident. Okay, and so to say that,
and had indeed been driving for years,
for a year at least,
or a year with that level of intoxication.
Right.
Yeah.
Okay. So that's the point, that like this is why he thought he could do it. And if you're going to say he should have known, okay, if he's driving in the other lane, if he's weaving in and out of traffic, if there are reports from people on 911 saying this guy's all over the road. I had a case where a young lady took 4 or 5 Xanax, okay, and she's driving on the freeway, and people on the freeway are calling 911. Somebody got to pull her over. She's going to kill somebody, and she did end up killing somebody because she was that out of control. She wasn't charged with murder. She was charged with vehicular manslaughter, which is the right charge in this case. But to think that somehow, this is some guy who couldn't maintain control of a vehicle and was all over the place and should have known better, that's not the case. That's the point.
The other thing I noticed while I was in court yesterday is the families of both the victim and the defendant, victims and the defendant. There seemed to be a large crowd on the defendant's side. Does he have a big family that's coming out to support him? And how close do you get to that family as you're pursuing this case?
Jacob has a very large family. They're of Filipino descent. They're very close to each other. His parents are split up, but they're both there. They've attended every day. They're there to support Jacob. They have nothing but sympathy for the loss of the victim's family, and they're very respectful to everybody. And they're doing what anybody would do when you have concern for a child. You show up, you support them, you let them know you love them.
Yeah. Well, the big turn in the case seems to be that's going to happen this week, and we'll come back and meet with you again, Ron, about it. Is Jacob testifying himself? Looking forward to that and how that's going to play to the jury. But also, is there any moment that you expect or you would see the prosecutor, if they want to give that out of a lesser charge to the jury? Is that something that would happen this week?
Yeah, it probably happened when we have jury instructions. These are the jury instructions the jury's going to get. I'm going over them right now, and they have to ask for the instruction for gross vehicular manslaughter. The big turn in the case actually happened yesterday on the expert of the defense, of the prosecution, sorry. We were previously not allowed to say that Jacob's executive functioning was off because of his age, and we weren't allowed to say his cognitive functioning was off because of his age, and we weren't allowed to say that he suffered from mania because of his addiction. However, I got their expert to say, without objection from the prosecution yesterday, that anybody who's addicted to Xanax would have cognitive dysfunction, meaning that they don't think as well, they don't make as good as decisions, would have their executive functioning of their brain would also be altered. Executive functioning part of the brain is the one that makes decisions for you, one that makes you make good decisions or bad decisions. What we say, young people have bad executive functioning, not fully developed executive functioning. That's why they make poor decisions. That's why you don't give a 16-year-old a Ferrari, for instance, because they make poor decisions. And then we also got out from the expert that people who are addicted to Xanax would suffer from mania, meaning that you have this grandiose feelings that you can do anything no matter what your situation. All that goes to the fact that Jacob did not have an intent to kill. This is the way his brain was thinking. He was thinking that he would be fine, that he can do this, and nobody's going to get hurt. That's what he was thinking. That's what they have to prove. Yeah. And yesterday, through their own expert, because frankly the DA was sleeping at the wheel, I got all of that in. So now the court, I think, has to let me have my expert talk about all that stuff and describe it in detail. because they didn't object and it was their witness and it all came in yesterday. So that was, to me, that was the highlight of the day. And then I almost made a lawyer blunder because I got this guy to say everything I wanted him to say, and I was going to ask the next question, and I could see he figured it out, that I had just gotten all this evidence in. He works for the sheriff's department. He's the people's pal. So, he figured out that, oh, I may have just fucked up this case, and I could tell he wanted to change it. And I was about to ask the next question. I realized, you know what? That's enough. And in mid question, I just stopped. And I go, you know what? I am good. I'm sitting down, and everybody's looking at me like, why did I stop right there? And because I just realized that, I shouldn't probably I should take the triple and not try to hit the homer. And the DA, I thought, would redirect, and she said no. She once again was not paying attention. No further questions, and we just wrapped it up.
Amazing, because that seems like, I mean, it's not like your theory of the case is a secret, right? I mean, we'll share all these podcasts later, right. But you're in court essentially pursuing this strategy, which is to sort of tack away at intent and all that sort of idea. So it's surprising that they're not picking up on that. It sounds like your expert did, though.
My theory of the case, as I said before, is that his prior experience let him know that he could do this without killing people in his mind. And the reason he thought that is because the addiction and depression he suffered from affected his ability to make good decisions, affected his ability to evaluate the facts coherently, and also because he suffered from this mania where he had these grandiose feelings that he could do anything and still people would live. And so I've been clear on that from the beginning. And that's why if you saw the first part of the cross, I talked about the officer's experience and how experience taught him more in the field than he learned in the classroom. The point of that is if his experience taught him, why wouldn't Jacob's experience teach him? He would learn. They would both learn. That's the whole point.
I wondered where you were going with the are I was thinking, are you going to talk about this officer's experience? But it's more the broader point about how you learn from practice.
Exactly. And since our theory is that Jacob learned from practicing, the thing is everybody thinks you get better with experience, you make better decisions from experience, but if you learned how to do things incorrectly, and that's your experience, you will continue to do things incorrectly because you think that works for you. So experience goes both ways, good and bad.
Well, we will see how the jury reacts to Jacob's testimony later, and I'm really interested to see how they feel about all of this. Thank you, Ron. We'll catch up next time.
All right. Thank you, David. We'll look forward to it.